Institute on National Affairs. My name is Evan Foltz, and I'm one of the co-chairs of the Institute. As you know, our Institute this week has as its main theme the Bill of Rights, the 200th anniversary, conflict and compromise. And today's panel is discussing the topic, do campus policies supersede the Bill of Rights? There are a lot of possible topics for this discussion. A lot of the more general topics have to do with freedom of speech and expression, search and seizure, and the right to due process of law. Some of the campus sorts of issues that we've had to deal with here at Iowa State have been, of course, the computer censorship that's been in the paper recently, and an ongoing sort of controversy over the last few years as to whether their speech code should be instituted here. I'd like to introduce the three panelists we have at this time. On my immediate left is Barbara Mack. She is the current executive assistant to President Martin Jischke. She's an associate professor in the Department of Journalism, and her field of expertise is constitutional law, particularly First Amendment law. Before coming to ISU, she was the chief counsel for the Des Moines Register, where she handled several free expression cases. On her left is Bamshad Morlasher. He is a graduate student in computer science and is a GSB senator. He is a member of several university and community committees, the ISU Committee on Equality, the University Steering Committee for Diversity, the Ames ISU Task Force on Equality, the Ames Human Relations Commission, and a committee to reevaluate the Student Conduct Code. Now on his left is Tom Thielen, the university's vice president for student affairs, which oversees which involves him with students outside the classroom. His office oversees the Ohio University Judiciary Committee and the residence halls. He has held his position for 16 years and has held similar position at two other major universities, the University of Minnesota Duluth and the University of Maine. The format for our discussion today will be something like this. I would like each of the panelists to talk for about 5 minutes about issues that they feel are important to this discussion. And then after each of them is finished, I will have them perhaps rebut any statements they've heard for 3 minutes or so. And then I'll open up the discussion to the audience. At 1 o'clock, those of you who need to leave can do that. We might be able to continue a little bit after if there's interest. So I'd like to start off with Barbara.
Thank you. First of all, like all good lawyers, I'm going to start my remarks with a disclaimer. The views you hear coming out of my mouth are the views of Barbara M. Mack. They are not the views of the university administration. I work for Martin Jischke. I don't speak for him. And he'd fire me if I did. My perspective on this is, as my husband tends to call me, the perspective of a bleeding heart, knee-jerk, bedwetting, free speech liberal leftist, which I think is actually a pretty good summary. He, as you can guess, is kind of the right of Attila the Hun, died in the concrete, conservative, and it makes dinner table conversation lots of fun. I come from a very strong free speech background. It has posed a tremendous number of problems and a tremendous number of ethical dilemmas. It poses some fun ethical dilemmas for me to struggle with as a feminist when I deal with issues like free speech versus pornography, which is not always the same as free speech versus obscenity. It poses some interesting problems for me as a person who attempts to lead a life dedicated to the equality of all human beings when I am forced to argue the correctness of legal cases that say that Jews should be able to live free of harassment, but at the same time I think that the Nazi Party has in fact a right to march on a public street as the Democrats have a right to march on a public street and the Republicans have a right to march on a public street. There are some challenging issues that face society at large, but I think the campus tends to become a flashpoint for those sorts of issues because campuses are about ideas. And I think on one hand you have the idea that a campus should be a place where people come to learn, where people come to work together, where people come to function as a community of students, a community of scholars. And you juxtapose that with the idea that you also have to hear some very harsh things. You can be a very strong feminist, but still have to deal with computer censorship or the alternative of pornography on university paid-for computers. They are not easy issues. I will tell you my personal perspective is to come down in most cases in favor of speech. I oppose censorship. I think that government censorship in most cases is simply a way to try and demand behavioral standards rather than motivate real change. And as I look at things from a historical perspective, I have very rarely found that attempts at censorship have ever worked. If anything, they tend to strengthen the resolve and strengthen the position, right or wrong, good or bad, of the individuals that hold the belief or who wish to engage in the behavior. You are not going to stop people from being Nazis by saying they can't march down a street. I think you have a better chance at persuading people not to be Nazis if you can argue with them in a free and open forum.
Okay, I'd just like to start first by commenting about the title of this talk, which is Do Campus Policies Supersede the Bill of Rights? And I guess I'll start by kind of taking issue with that because I feel that title is predicated based on some inherent, as if there is some inherent conflict between campus policies and the Bill of Rights. And my view would be that, well, in general, at least to this point, and as in the context that we are talking about in terms of including bias, for instance, in the codes of conduct of the universities, it is not an inherent conflict between the Bill of Rights, at least as I understand it, and those policies. The title of this week, however, the Institute of National Affairs is the Bill of Rights, 200 Years of Conflict and Compromise. And I think that's a very appropriate title since that one, there's an implication there that there's an inherent notion of a balancing act. Not only, well, there are two things that I think is essential to what I'm going to say, and one is this notion of the balancing act, where you constantly strive to try to balance rights versus rights, and you balance different values. But also it brings in this historical perspective that this whole notion of the Bill of Rights, it didn't stop once the Bill of Rights was ratified. It continued, and it's been going on for 200 years. 100 years ago, more than 100 years ago, there were still slaves in this country. This was a long time after you had the Bill of Rights. The Bill of Rights included the First Amendment, but obviously that didn't apply to blacks, that didn't apply to slaves. It didn't apply to women, they didn't have the right to vote, therefore effectively not having the right to free expression and free speech, at least certain forms of it. And that wasn't changed until quite a long time after the Bill of Rights was signed. So you need to look at this in context, in a historical context, and also in terms of this balancing act. What do I mean by this balancing act? I'm not going to start with the First Amendment. I'm going to start with the Ninth Amendment to the Constitution, which says that enumeration in the Constitution of certain rights shall not be construed to deny or disparage others returned by the people. Now, it's important to think what that means, these rights. And if you think of this Constitution as kind of a living document that's been developed over 200 years, these rights have been defined over hundreds of years or a couple hundred years, and it's a continuing process that's happening. This balancing act is between, essentially, I think, two things. One is this issue of rights. The other one is a set of values. And I'll get into that more, but before I say anything about that, I'd just like to mention very quickly that I think most of the publicity and the barrage, the media barrage over this issue of political correctness, free speech versus speech codes and all that stuff that you hear on Nightline, you hear in every newspaper and magazine you open up. Most of that, I think, is hype. I think free speech right now and the quote-unquote political correctness is being used essentially as a polemical weapon by the right wing. Sure, there are liberals and leftists and diehards and whatever that also truly believe in free speech and truly believe in First Amendment and have done that. But the attitude out there is that as if there is some magical, new, novel restrictions that are being imposed in the university and other places on free speech, which is not true. It's never been true in the universities in various contexts, at least not in recent years, that anybody could say or do anything that they wanted to do and engage in any kind of behavior, regardless of any consequences that it might have. Title IX, Title VII, the sexual harassment laws that exist right here in this university. And there are many other examples like that. So we need to talk about these values, and that's essentially what I believe is that the issue is not free speech at all. The issue is not law. The issue is value judgments. What are the value judgments that this society is willing to make, that we as people need to make in order to redefine or further define the rights of the people that they have in order to be able to pursue on an equal level their life, just like anybody else in the society, especially in the context of an institution of higher education. The context, as I said, is a historical context. The freedom, the First Amendment was developed, as it was developed apparently, was to prevent the government from controlling people's thought, from controlling them, from criticizing the government, to prevent the government from controlling them, from expressing views and engage in debate to convince other people. But the question is all speech like that? There are obviously lots of different types of speech that there's always been lots of different types of speech that has either been regulated or outright banned in this country. And none of these got nightline attention before, until the issue of race and the issue of racist harassment in San Jose universities came up. Libel, false advertising, for instance, against some of the things with sexual harassment. The sexual harassment policy of Iowa State University says, Iowa State University reaffirms and emphasizes its commitment to provide a professional working learning environment which is fair and responsible, which supports, nurtures, and rewards educational and employment growth on the basis of relevant factors such as ability, performance, which is free, ability and performance, and which is free of discriminatory, inappropriate, and disrespectful conduct or communication. Sexual harassment threatens this environment in that it comprises institutional integrity and corrupts traditional academic values. What is in here? First of all, it's already talking about certain types of speech in certain contexts are prohibited. Number two, it refers to certain institutional values. And I think it's these values that really we are talking about. Even in famous cases like Chaplinsky versus New Hampshire, these famous fighting words cases, and lots of other Supreme Court cases, the issue always comes down to look at speech and see what were the consequences of the speech. What are the possible benefits as opposed to the injuries that it might cause. And that's the balancing act. It's between these values. You make a value judgment that if you, let's say, regulate certain type of speech, you have made a value judgment that consequences of that speech or hurtful consequences of that speech may be more than its benefits by not regulating. Those are the kind of value judgments that are at stake here.
Thank you, Bob.
Okay.
I'm sorry.
Go ahead.
Dr. Tillman.
I assume the reason I'm on here is to look at maybe the administrative stance on this. Although what Bombshell said, this does hit two. When you talk about values, we're talking about really two of the highest values that I think a university or a college has, and that's one of them is civility, and the other is expression, freedom of expression. When one of those are violated, and they're usually violated in relation to the other, that's why it's so important. And I'm glad the committee that put this week together is looking at this. and I hope some of the questions will come out today. I would just say this, that the institution, whether it's Iowa State or any public institute, I'm really referring to the publics right now. The privates don't have to do quite what we do. But we have the right and the responsibility to establish reasonable standards and procedures for admissions to the university, for continuation at the university, for termination at the university, and for readmission to the university. We have to do that. And then once those standards in academic life or in non-academic life on this campus are established, we have the responsibility, the people of the university, to provide these standards and requirements in a timely and understandable manner to the people that study here and work here. That's kind of the bottom line. The institution has the right to expect students and staff to honor these terms and requirements or standards, whatever you want them to call them. And the institution has the obligation, I believe, to enforce whatever standards they say they have. I'm going to say a couple things that I would hope might spark some response here. I think the institution has a right to remove from the institution any individual who are deemed to be a threat to others, to themselves, or to the property of the institution. And I think it's obvious that the university has the right to remove people who are disruptive to the operations of the university from the campus, not necessarily from the institution, but remove them from the campus. But after saying that, the institutions, like ISU, cannot take away a student's constitutional right when they do that. And that's the kind of the balance that we have to look at here. The right to speak, the right to assemble, the right to express in any form cannot be abridged in doing what I just said. And I think the concept that I would just like to end with, and I think that really the one that you were relating to, is the time, place, and manner. I don't think we need speech codes. I don't think we need all these regulations. We do have one, and that's the university can regulate within reason. It has to be reasonable, the time, place, and manner of any of these freedoms. I just stop there.
Thank you, Paul. I'd like to go through now if any of you would like to make a short and to the point rebuttal of any of the statements that you've heard.
Just jump into questions.
So that if we can do that also. Subject
Pardon me.
Okay, we can open the floor to questions. Do we have any questions for the panelists?
Actually, you can always talk because I can see people kind of doing that.
Question over here.
I have a question to Dr. Stevens about, I'd like to define your definition of a threat.
A threat to self or to others. Well, I think that's an interpretation. It's a complex issue. You just can't, you better have a good defense when you do it. What we try to do here is that if we deem someone as a threat and needs to be immediately removed from the environment, that decision is made, but with the idea that the person, we can't ask this person to leave the institution without a hearing. And when we deem that that person can have that hearing has to be given. I'm not sure if
I might jump in here and say, when you look at the case law on this issue, I think one of the places where speech codes tend to come into conflict with cases like Chaplinsky is when you look at the line of cases the U.S. Supreme Court has handled, where the government, and in this case at a public university, the university in fact stands as the government, when the government attempts to censor a person or to stop a person from speaking, the rule of law is generally that the threat has got to be a threat to the physical well-being of an individual. In other words, I may not be able to say, I'm going to kill you, Dr. Thielen, I'm going to rip your heart out and feed it to the geese. that constitutes a threat. But I may in fact, and I think it's pretty clear that under current U.S. Supreme Court law, I can say, Dr. Thielen, you are so stupid, you haven't earned your paycheck since 1975. I have no idea why I've been paying you. You have the brain of a mushroom. You ought to resign and save the taxpayers' money and get the hell off our campus. I haven't threatened his well-being. I've expressed an opinion, which actually isn't my real opinion. It is, I hope you all know.
Some of it press, right?
The geese wouldn't eat it. Now that's a, Tom and I work together a lot, and we are dear friends, which is why I thought I could use him as an example. Tom, we are in fact very dear friends, and I respect him and value his counsel highly. I'd be lost without him. But it's very difficult when you put that in a more serious environment, in a campus environment, where you see someone who wears I don't know, a T-shirt I saw on this campus last semester that said, "It's a black thing, honky, you can't understand." Or if you see someone who wears a shirt that has Tracy Lords, who I understand is a pornographic movie star, or if you see someone sitting at the computer scope next to you looking at pictures of naked people, that may distress you. It may make you feel uncomfortable. But is it the kind of speech for which you ought to punish that person when your physical well-being has not been challenged?
Could I just add that that's really what we look at, physical violence to themselves or to someone else, nothing else beyond that. And that's still a judgment call.
It's a hard issue.
Okay, let me jump in here and disagree for a second, because there's too much agreement in here right now. Here is just continuing reading on the sexual harassment policy of the university, and I'd like to know your comments about that. The issue of threats, if you want to restrict it to this fighting words doctrine, which I think has a lot of problems, because there's a lot of things that are unclear. At least, I'm not a lawyer or a judge or a constitutional expert, but when you read these things, there are a lot of things that are unclear. But there are some things that are clear to me. Here's the definition of sexual harassment the university defines. Sexual harassment may consist of requests or demands for sexual favors, unwelcome physical advances, or conduct, verbal or physical, of a sexual nature that is intimidating, demeaning, hostile, or offensive. It doesn't say anything about threat of violence. It doesn't say anything about all of a sudden causing some people to jumping up and down and disrupting the peace. It talks about creating a type of an environment in which other people cannot freely exercise their rights. That's really, when you come down to it, that's what you're talking about. The Supreme Court has constantly, including the Title IX stuff for sexual harassment, Title VII for discrimination in employment, all of these things have been supported by Supreme Court case after Supreme Court case. You can list them down. I have some of them right here if somebody's interested in seeing. The question here is not fighting words. The question is exactly that kind of environment. And what you're doing there is, again, making a value judgment. The institution is making a value judgment. The Congress has made a value judgment that there are certain types of conduct, okay, which is speech, in fact, in some cases, which is going to threaten the very values that that institution stands for, and that it's better to regulate those. It's more benefit, brings more benefit or less harm to regulate those kinds of things than not do it. I would agree with Ms. Mack on the issue of should Nazis be able to go and have a lecture or have a rally. Yes, I think that's their right. But if you create in the residence area where all the students have to live in one floor, let's say, if somebody through their behavior, their conduct, or through racial epithets or pictures in public areas or whatever, creates a type of environment where, let's say, an African American who lives there is going to be in fear of their life or is going to be intimidated even into talking Okay, they talk. People always jump in and say free marketplace of ideas, as if if you're hurt by some speech, if you talk more, it's going to take the hurt away, as if it's not going to put you down, and it's not going. And the answer generally is like internalizing the repression when those kind of things happen by people that are subjugated by those kind of things. That's really what we are talking about in here, especially when you're talking about a university. And I think those kind of things need to be regulated. And yes, I believe you do need to include those things. Sexual harassment is already included in the code. Why not say something about racial harassment? Why not be specific about it? Why not say that we think that racial harassment of people of color on this campus, for instance, of international students, or homophobic harassment of gays and lesbians, deserves as much scrutiny as drunkenness, which you have all sorts of policies for. Why not say that racial hatred and racial harassment in those contexts should have the same scrutiny in the context of the nation as libel laws? When Volvo reinforced the ceiling of its cars and then trucks went over into the TV ads, there was an uproar. All sorts of things. You can't do that. That's illegal. Libel. False advertising, stuff like that. Where are those people when it comes to racism? Why can't this country, why can't we as people in this institution make the value judgment that tells us this is just as important as Volvo reinforcing the ceilings of its cars and do false advertising? The question is value judgments, it's not free speech.
No, there's a question back there, a couple of questions back there.
I know there's one over here.
There's one way in the back, too.
I have. Well, you go ahead.
Okay, to bring this all at home, I'm a resident assistant in a residential house. And
You
so-
poor thing.
That was a great job. But I see, and I confront different harassments, including ethnic, including sexual harassments. And I agree that we should all have public speaking and that we can have free speech. But living in the residential house, you have to have some kind of rules. You cannot have on your doors things that would agitate black people, things that would agitate Jewish people, things that would agitate homosexuals, lesbians. You cannot do that because in our environment, in the residential house, we want to have a community where we can all live. We call the residential hall floors houses. The reason we call them houses is because we're a bunch of people living together. We eat together. We sleep in rooms next to each other, and we communicate with each other with our weekly meetings. So I agree that we should have some, like a median of what is allowed outside of our doors and what's allowed in the residential halls. I know that's not saying that we should have free speech, but when it comes to living such close quarters and living at our age, I mean, most of the residents in the halls are from age 18 to about 24. You got to watch that, and so that's what I feel as resident assistant.
I would jump in by saying that I thought that the university really screwed up dorm door 1 and dorm door 2, as I call the cases. The one case which had homophobic messages on the door of the dorm, and the other one of which was a cartoon about Saddam Hussein. And in both of those cases, student lodged complaints. My theory is, and I actually think the U.S. Supreme Court, for a change, happens to agree with me, that the university should not make decisions based on the content of the speech in residence halls. Otherwise, you get into saying, well, can you have a Tracy Lords picture if she's wearing a bikini, but not a Tracy Lords picture if she happens to be naked? Or can you have a Tracy Lords picture if she's naked, but gee, she can't be holding some implement of sexual pleasure? What if you have Tracy Lords in a nun's costume, but everybody knows that Tracy Lords is in fact a pornographic movie star? My opinion is that the residence halls are owned by the university. They're university property. We have the right to say, as a university, to make legitimate time, place, and manner regulations. We can say that nobody gets to speak on central campus for more than 24 hours in a row. We can say that no more than 9,000 people can gather someplace because it's not safe, or you can't play your stereo at more than X number of decibels after midnight. Those are legitimate places for regulating the time, the place, or the manner of speech, but not its content. And I think my reaction to that is saying, rather than getting the university into a business of attempting to decide what is or what is not appropriate speech, then the more appropriate reaction would be to say, this is not a place for public speaking. You can do whatever you want inside your dorm room. Nobody has to go in there. The walls of the dormitory and the halls of the dormitory are not places that we have decided are public forums. You do not have a right to put anything up on your dorm door. Ask people to come inside if you want them to see your collection of Tracy Lords pictures or Nazi memorabilia or Oliphant cartoons.
Any other panelists like to jump in on that?
I just like to say one thing is that I agree basically with the implementation
Whoa,
of what you're talking about.
there's too much agreement here.
But there is one thing that I don't agree. I don't think you can separate speech from content. I don't think you can separate conduct from speech. I don't think there is any speech that's without content. I mean, certainly when you're talking about sexual harassment, you can't go in a workplace. Sure, you're regulating time, manner of speech, but you're also regulating its content by doing that. The issue is the content. The issue is the content, and you are making a value judgment. The institution is making a value judgment that no, you cannot go into a workplace or a classroom or things that apply under Title IX or whatever in this country or in this university, and use communication or speech in a manner that's demeaning to women that work there, for instance. It's against the law. It's against the federal law. Supreme Court supports that. Why not do the same thing and apply the same principles to the resident areas, for instance, in terms of the racial harassment or homophobic harassment, in the classroom, in other places? I'm not saying if David Duke comes here, for instance, and wants to give a speech, sure, that's fine. I would not support saying no, David Duke cannot come here. I try to organize hundreds of people to go and protest it, but I think that would be the answer there. But the issue would become different when you're in a situation where your conduct is creating a type of environment where other people's rights are going to be at stake.
Okay, there's a question over here.
And, speaking of conduct, safety, et cetera, we're also RAs, resident assistants at the university. And out at Towers Residents Association, we have a situation where the windows of our vehicles are being shot out, et cetera, due to actions with us enforcing our jobs. And we're just curious as far as what sort of measures does the university have to make us feel safe, our property feel safe within the university, and that sort of situation.
I assume this has been reported and people are investigating this.
Yes, sir, it is.
And I assume that if they're found, that I'd go back to my earlier, if it's a point that we feel this, and anything with a weapon, I would say we would remove that person, if that person was a student. If that person is not, I would hope that they would, the local authorities would take care of it. It's very dangerous. I don't know if you were asking for anything more than that, but it's got to be dealt with.
Just as far as, for the residents assistants, security personnel, et cetera, what is there for us and security, elevator operators, whatever? Because a lot of positions put our vehicles or property in easy access and easy identification to protect us and our personal matters. And as far as the university standpoint.
Are you saying would the university do that? Would they?
What is there?
I would assume that that's happening on a regularity, that the Department of Safety would, if nothing else, put a guard out there. That should stop. Now, that hasn't been done?
They have, the security of paths and surroundings doesn't include about 61 towers. But in addition to
but there are crimes being committed.
Correct.
you're saying. Well, I would hope we take immediate action. You don't think you're getting that kind of action?
No, we do
All right.
not, sir.
This sounds like a see Dr. Thielen immediately
All
afterwards.
right. Yeah, I'd like to talk to you. I wasn't aware of that.
There's a question right here.
We're wondering here, how can the university give purely textual discussions? This has nothing to do with pictures and media, but purely textual discussions about sex crimes, including legalization issues.
I'm not sure I understand what you mean by textual discussion.
See, the main issue that the university is trying to
You speak.
You speak.
Yeah. Oh, good. I thought it was because I was like 40. I get it.
The university is trying to make an issue of pornographic pictures that are being distributed over the networks, but they've also eliminated discussion groups about sex and drugs, and this is nothing.
Oh, the billboards?
Yeah, bulletin boards that have nothing that
Or,
yeah, pornographic pictures are not sent through this network, and yet we are not allowed to read them. We've not really gotten any satisfaction from the Competition Center.
well, I don't differentiate a whole lot, and neither does obscenity law, between whether something is written out or whether something is an image.
But these are not obscene. It's not obscenity. They have discussions about birth control, AIDS, rape. It's legalization issues, the war on drugs. These are not illegal discussions. And yet the university is restricting them.
It's my
Nearly all of these students.
my understanding they're indicating on what terminals that you could use this on, or are there? It's more of a traffic management than restricting. Now I haven't been involved in these discussions, but it's my understanding that you could see those screens, but they're asking you to sign up to see them. Am I?
That is a privacy issue there. I certainly don't want to be on some list in somebody's office that says I'm a drug abusing pervert. I mean, if I were to sign up for these groups because I wanted to read about, let's say I were on antidepressants or lithium or something, which was dispensed by Student Health, and I wanted to read a group entitled alt psychoactives, which is about like cough medicines and several types of psychoactives which are prescribed. I can't read these because the university is restricting me from them, and therefore I have to sign up on this list of dirty people. And I mean, they're saying that they're going to privacy of this list, and it remains a list, and it's written down somewhere. And these files can always be subpoenaed. If I wanted to become a senator, if I wanted to become the president of the United States, they could always check and say, oh, she signed up for this, so obviously she wanted to look at pornography.
Well, it'd make your Supreme Court hearing, confirmation hearings, kind of real exciting.
Yeah.
Yeah.
In the case of divorce.
You're saying that it's unreasonable to ask you to do that.
Yes,
That's what.
think
Yeah.
it's-
Well,
For something so simple as textual proofs, I can almost understand it with, I can almost understand it with pictures, because I think that works on sexual harassment. When somebody's putting up this large picture of a naked woman and somebody could walk by and be easily offended, there's no problem with that with the textual proofs. And if somebody is reading about rape, or even, different sexual positions, it's not going to offend somebody who's walking by. They certainly shouldn't be reading the screen in the first place.
I just could like throw something in here. I think this policy is not only unreasonable, but it's stupid. It's really the only way to call it, because universities' concern, and I think that's an important concern, was universities' liability in terms of sexual harassment. When in a public place, if you're on a big Vincent workstation, you're displaying a naked woman or something, I don't know, whatever. That could be construed as sexual harassment, and it is, in a workplace or in a classroom or public place, you can't go and hang like Playboy Centerfold either. It's the same concept. But those are the kind of things that sexual harassment policies are to deal with. To restrict access to certain news groups is stupid, for one thing, because you can't. You can't restrict access to that kind of information. There's nothing to prevent people from sending the same material to other people through electronic mail, or just post it into another group, or whatever. So even if you restrict access to those groups, the same people could get access to it through another means and display it on the same workstations. That would be okay then? See, that doesn't cure the problem that the university was after to try to cure. So I think the policy essentially is a stupid policy. And I don't think it's going to last.
I would tend to argue, because a lawyer can always argue the flip side of the coin, that the university shouldn't have to pay for anything it doesn't particularly need or want to buy. And if I had been making the argument, I would have said, gee, we don't want to buy this anymore, y'all want to go buy it, y'all have a good time, but we don't intend to pay for it. I happen to be in a position of disagreeing with what the university has done in terms of creating user lists. I think it's unwise. It reminds me a lot of what happened to the Iowa librarians, and in a moment I'm going to call on Nancy Eaton, so I'm alerting her that I'm just going to embarrass the hell out of her in a moment. The librarians in Iowa are a real feisty group, and you never want to try and screw a librarian to the wall, or you're going to be in trouble. The police in Indianola were trying to figure out who was killing cattle in satanic rituals, and they subpoenaed the Indianola librarian and the Des Moines librarians to get the circulation records to see who had checked out books on Satanism, so they could go investigate these people and see if many of them had like a lot of steaks in their freezer or something. I don't know. And the librarians actually said no, went to jail to protect their circulation records, and got the Iowa Supreme Court to pass a bill which exempts the circulation records of public libraries from the Iowa Public Records Law. And they quit keeping identifiable lists of users. So now they can show that book XYZ was checked out on these dates, but they don't know by whom anymore. Which I thought was a good way to resolve the issue from them, but they were resorting to librarian guerrilla warfare to do so. I think Dr. Nancy Eaton, who is our Dean of Library Services, has some interesting thoughts on this issue. I was talking with her before we started.
Can you hear me? I've stated in writing to the director of the Computation Center that I'm very concerned about the privacy issue, that I believe the current Iowa law, which protects identification of individuals for use of library materials by concept, should be extended to electronic information, and that we should in fact even consider going to the legislature and asking to have that law extended to the new environment in which information is being transmitted. I've also raised several other issues with the Computation Center. One being whether all information in a news group is being looked at when they try to apply the Iowa law on pornography, because it's my interpretation of the federal law that you should look at the entire content of a news group and not individual pieces within it, and it's not clear to me that that is the way the judgments have been made. It's a very difficult area in that we're trying to apply case law that applies to print and transfer those decisions to a new medium. The electronic bulletin boards are international. There's no editorial process on those bulletin boards, so it's not a one-for-one comparison of the old print environment to electronic. We have to try to take the concepts and move those over, and then and probably in many cases create new laws to protect the new publications and information transfer medium. But my personal feeling is that the major concern that started this discussion on campus is the Iowa pornography law, and that we're not looking broadly at the intellectual freedom and First Amendment issues involved, and we should be taking a broader look.
Thank you,
I think it does, but I would,
Yeah, but you know, I could also make you a good case that says if you are the only person who sees the information, it is by definition not material which can harass another. You know, I think that the tough issue you get into is if you're having to work side by each with somebody that decides they want to look. And why do we keep talking about naked women? Are there no naked men on this, or am I losing something? You know, there's an equal rights issue here too. Someone who is looking at you know, pictures which are pornographic, perhaps, but not necessarily meeting the legal definition of obscene. If you're the only person who can see them, you can't harass, but I do think there's a real issue where you have material that can be seen by a multiplicity of individuals.
Right, no, my point is